Judge Kennedy, you may proceed with the program.
All right, thank you, Lionel. Welcome to the American Bar Association Science and Technology Section's webinar series on video and legal decision making. Today's installment, which is the last installment, has to do with police body-worn cameras, where they go, how they're used in court, how they're used well, how they're not, and both the promise and the problems that can come up when they do get to court. The person chairing our session today is Dr. Sandra Rostovska from the Media Studies Department at the University of Colorado Boulder. She is a Mellon and ACLS Scholars in Society Fellow who has come to the American Bar Association Science and Technology section, particularly the Scientific Evidence section, with a grant, and she was looking for housing, and we decided that we would love to have a program on how to use video better in court, with an eye toward developing standards for its use and better ways of understanding it when it is used. And with no further ado, I will turn this over to Dr. Rostovska.
Thank you, Judge Kennedy, and thank you everybody for joining us in what has been an amazing webinar series. Today's session is being recorded and will be posted where you can see also the prior sessions in case you missed them. It is my great pleasure and honor today to introduce you to three amazing scholars who have been working in this space who are going to share brief presentations with us today to get you inspired thinking about some important issues. We ask to keep the questions at the end. However, in case something comes up or you need any clarification while the presenters are giving their talks, please feel free to type them in the chat, and I'll be monitoring the chat and make sure I ask all of your questions at the end. I'll introduce the speaker all at once, and then they'll present in that order. So first is Professor Mary Fenn. Professor Fenn is the Jack McDonald Endowed Chair at the University of Washington School of Law, a former federal prosecutor in the Southern District of California, and an associate legal officer at a UN criminal tribunal. Professor Fenn is a leading expert on criminal law and procedure, evidence, and information privacy. She's the author of numerous articles, including two critically important books, Camera Power, Proof Policing Privacy and Audio-Visual Big Data, which came out with Cambridge University Press in 2019, and A Perilous Science, Lessons from Firearms Violence Research on Knowledge in Political Minefields, which will be coming out with Stanford University Press next year. Professor Fenn has been a visiting professor at Stanford Law School and a visiting scientist at the Harvard School of Public Health. Her teaching, too, has received multiple awards. She's an elected member of the American Law Institute and an elected life fellow of the American Bar Association. She also serves on the board of directors for the American Civil Liberties Union in Washington. Next, we have Bryce Clayton Newell. He's an assistant professor of media law and policy in the School of Journalism and Communication at the University of Oregon. He's also jointly appointed as a researcher at Utrecht University School of Law in the Netherlands. Professor Newell holds a JD and a PhD in information science, which gives him a unique research perspective on questions situated at the intersections of surveillance, privacy, policing, immigration, technology, information ethics and politics, and the law. He's the author of numerous articles and books, including his well-received monograph, Police Visibility, Privacy Surveillance, and the False Promise of Body-Worn Cameras, which came out with University of California Press in 2021. Professor Newell was a postdoctoral researcher at the Tilburg Institute for Law, Technology, and Society in the Netherlands. And during his PhD program and studies, he was a Google Policy Fellow at the University of Ottawa's Faculty of Law. He's the co-director of the Surveillance Studies Network and dialogue editor for Surveillance in Society, the leading international scholarly journal dedicated to the study of surveillance in society. And last but not least, Professor Rebecca Wexler. She's an assistant professor of law and a faculty co-director of the Berkeley Center for Law and Technology at the University of California at Berkeley Law School. Her research and teaching focus on data, technology, and secrecy in the criminal legal system, with a particular focus on evidence law, trade secret law, and data privacy. Her scholarship has appeared or is forthcoming in the Harvard Law Review, Stanford Law Review, Yale Law Journal Forum, UCLA Law Review, and many others. Professor Wexler's scholarly theories have twice been proposed for codification into federal law and litigated in multiple courts, including a petition to the US Supreme Court. Her article, Privacy is Privilege, received an award from the Privacy Law Scholars Conference in 2020 for an overall merit for a paper by an untenured faculty member, and was named a 2021 must-read article by the National Association of Criminal Defense Lawyers. Her op-eds have appeared in the New York Times, the Los Angeles Times, Slate, Washington Monthly, and many others. Professor Wexler is a non-resident fellow at the Brookings Institution and an affiliated fellow with the Information Society Project at Yale Law, where she co-founded the Visual Law Project. Prior to attending law school, she made documentary films for national broadcast television, museums, and educational distribution. It is my great pleasure to introduce and welcome all of our speakers for today. And Professor Fenn, we'll start with you.
Excellent, Sandra. It's such a pleasure and honor to join you. I am a huge fan of the work of the folks here on this panel and of you, Sandra. I'm excited for your grant-funded research in this area. And Judge Kennedy and I have already had some fascinating exchanges that you're going to see inform the presentation today. It's a pleasure to see law enforcement officers and lawyers and people from a wide array of backgrounds in the audience today. Looking forward to your questions. And just to dive right in onto evidentiary and policy issues, a topic for today. It's a dramatically different time right now in terms of recording law enforcement encounters. When I was a federal prosecutor, not that long ago, it was a challenge to even get a tiny sliver of the investigative process recorded, and that was interrogations. Even to get the interrogation recorded was a challenge to convince officers to do so, to deal with technological issues and policy issues. And now, since 2015, we have an exponential increase in the number of police departments across this nation that have undertaken to adopt police-worn body cameras, along with a suite of other related technology. And it's a dual recording revolution. We often focus on police-worn body cameras, but there's also the rise of citizen cameras, community member cameras. When something goes down in Baltimore or DC or in communities across this nation, people in the neighborhood will take their cell phones and they'll record in case something goes bad. And we also have organized cop watching groups. The idea is to create video to counter the dominant law enforcement narrative. So we have cameras from multiple sources. There's dual revolutions when it comes to recording the police. And we've seen through the heartbreak of our times, the difference a camera can make. If there hadn't, imagine just in these cases, if there hadn't been recordings, things would have been so different, whether it be the Chauvin trial, whether it be the shooting of Walter Scott. In controversies across this nation, the camera made all the difference. The camera recording that in some cases contradicted multiple official police reports. Cameras have the power to take the case to the people. Recordings have induced civil rights settlements in a number of these heartbreaking cases. Of course, money can never heal a community or a family who's lost the person they love. But the idea is, it's an advance in no recognition at all. much less any remedy. A long burning challenge when it comes to use of force. Now, there are there's much touted hopes, and we'll talk about some mixed data about hopes about things like de-escalation, violence prevention. There's transparency. There's a lot of hopes that ushered in the advent of widespread body cameras, many more modes of surveillance on the streets. Community members pay that privacy price because there's all these hopes that there are benefits, and we'll talk about the data and how empirical data is currently mixed on those benefits. I'm going to go into some of the perils of widespread recording, and I'm going to save something. I have wonderful panelists who are going to delve into some of these issues more. I've written about this, as have my colleagues, in the book that Sandra mentioned. But we've definitely seen here in Washington State, where I am on this rare sunny day, privacy and potential dehumanization harms. For example, in a state like Washington State that has very strong open record sunshine laws, we have people who have requested body camera footage. And if you think about it, police enter the most painful, humiliating, stressful moments of our lives. And we tell police very intimate things about our custody arrangements, our battles with our partner's ex, our children, etc. And imagine now all of this posted on YouTube by someone with no relation to the case, and then open for the cesspool of public comment, anonymous public comment. And so these are some of the examples of the potential privacy and dehumanization harm. So we pay a privacy price for exponentially more cameras in our communities. And the hope of it, one of the hopes, is that we may have better evidence, particularly in hotly contested, police said, suspects said, community members say, credibility contest. The idea is we're going to have more objective evidence of what really happened, and more evidence is great. It's excellent. However, we also must enter into this with caution, because video evidence has a seductive peril, has a seductive danger in terms of making us think we really know what happened, and yet. And we can, when we see a witness on the stand, we can say, oh, that person has bias, that person has self-interest. We discount some of the things they say. We look at the twitches on their face, their nervousness, their evasiveness. But when we look at a video, we think, oh, this is the recording of what happened. But we don't we have to also educate ourselves about the potential partiality and biases in video evidence. Here's just one example of the potential perils of video evidence. This is from the Derek Price case. And my question to you is, was Derek resisting arrest, or was it excessive force? Check out the body camera video versus the private camera video.
You. Okay, get your hand behind you! Stop resisting! Get your hand! Stop resisting! Stop resisting! Okay! Stop! Okay! Put your hand behind your back! Now! Give me the other hand. 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 Your hand. 10-12.
So, pause there for a second. Let me pause there. So you see the camera from the officer's perspective. It looks like the subject is bouncing. It looks like the subject is resisting arrest from this. By the way, shout out to Professor Seth Stoughton, a former officer himself before becoming a law professor, who has a trove of similar such videos and shared this clip with me. Now look at the now judge the incident from the perspective of a different camera.
You. Okay, get your hand behind you!
I'm going to stop there because another harm of video cameras is dehumanization, in the sense that somebody's worst moments are played out, most humiliating, painful, traumatic moments are played out. So I don't want to overplay these worst moments, but it's unless there's an important point. And the important point is this: what looked like the subject resisting from a different angle, from another camera high above, now you see actually the bouncing is from the use of force on a prone, compliant subject. So very different legal findings. Angle, perspective, timing makes a lot of difference, as you see in these two photos of the same exact gesture. So something that Judge Kennedy and I have been discussing is video evidence and evaluating use of force. The law, Graham v. O'Connor and its progeny by the Supreme Court, says use of force is evaluated for objective reasonableness from the perspective of a reasonable officer at the scene, and must consider that officers are often forced to make split-second decisions in the heat and fray of high-stress situations. So that means, and so sometimes there's a temptation in contested encounters to say, let's look at the video. Let's maybe even enhance and blow up the video. Let's see multiple videos. But you have to understand that when you're evaluating use of force, the proper yardstick, according to the court, is somebody with in high stress, your field of vision actually narrows. And what in that high stress situation that officer sees in front of them at the time. These are photos of officers being attacked during the Capitol riots. And you see if a camera is poised above, you see something. But imagine if you're in the middle of people trying to beat you up and what you're actually perceiving. It's going to be different than somebody in the cool remove high above the fray of situations such as this. So it's a caution that works both ways for both the government and the defense. So sometimes it can cameras can be unfair to the defense, and sometimes it can be unfair to the officer as well. So cautions when we use video evidence. We have very little time remaining, so I'm excited to hear my colleagues' presentations. I've written elsewhere about another challenge that's emerging, and I presented to defense attorneys about this, and it's a challenge that defense attorneys are seeing, which is missing video. And we've seen pain erupt from either video that's missing key moments or video that may exist, but it's not being released to the public or even the grieving family. This is a major challenge. Policies vary across the nation with respect to whether the public can get access to the footage and also what happens if footage is missing in contested encounters. There are potentially judicial remedies that attorneys can seek, as well as roadblocks to the remedies in terms of trying to get accountability for missing video. Of course, video can be missing for all sorts of reasons. It could be technological malfunction, we've all been there, but it could be intentional subversion as well. And it's a real concern that we should have, because one of the promises or hopes that led communities to accept the advent of way more surveillance in their communities was the idea that not only would we know what happened, but potentially if everybody knows they're on camera, they'll behave better. The results are mixed. They're frankly mixed, especially with more recent larger scale studies. One of the most interesting findings is effect modification by officer compliance. What does that mean? Well, use of force actually increased. This major study found that use of force increased among officers who basically recorded at their discretion, didn't follow recording procedures, but use of force decreased among officers who complied with the recording protocol. So having incentives for officers to record as promised or as directed by policies is a major challenge. And I've written elsewhere about this, but I want to now turn it over, because we're at time, to my colleagues. Thanks so much.
Thank you very much, Mary. Fascinating, and I'd love to hear about all the work that you're doing. Another plug for Mary's excellent book here. I've got sticky notes all over it. She's done really great work in this space, and so if you're interested in learning more, I'd certainly recommend it. My presentation today is going to be drawn largely from several studies that I've done with a few police agencies in the Pacific Northwest and in the Midwestern regions of the United States. And I'm going to touch on a few different issues, but at the end, I'm sort of focusing on some of the issues, some of the responses and perceptions of officers in the studies that I've done about how wearing a body camera affects the way they think about reporting, writing reports, particularly in use of force cases. And so that's sort of where we'll be headed here. But I want to start out with sort of this, the same sort of dual revolution that Mary talked about. And I think that a lot of the things I have to say here will build a lot on what we've already heard. This was an image that appeared in a slightly cropped version of an image that appeared across the centerfold in Time magazine about a decade ago now. And this was a photograph that was taken during the Occupy protests at the UC Davis campus in California of protesters, student protesters largely, who had sort of locked arms and sat sitting across the sidewalk on the main quad on campus. In order to disperse them, a couple of officers used pepper spray. And one of the interesting things here, right, is of course this issue that Mary talked about, that sort of everyone is pulling out their cameras and filming. I love this one because if you see up in the upper right, if you can see it, it might be small on your screen, but there's actually someone has a laptop computer turned around, apparently is trying to record with the webcam, which I find is a sort of interesting artifact at that time as well. But we know that there's a lot of video, right? And it's sort of, I think, uncontested now that police are recording a lot more frequently now. Bystanders are recording all the time. And we have some really interesting precedent that's building in the courts. So just a couple of select examples, and there's many more here. But this is from a Third Circuit decision in 2017 called Fields versus Philadelphia. And in this decision, the Third Circuit said that described civilian video as filling the gaps created when police choose not to record video or withhold their video from the public, right? So as a response to this missing video problem that Mary talked about. They also said this, right? So, quote, to record what there is the right for the eye to see or to hear, or the ear to hear, corroborates or lays aside subjective impressions for objective facts. Hence, to record is to see and hear more accurately. So within this case and a number of others, we see, again, this I think this penchant of judges and others, and even in everyday life, we see this as well, right? Where we think that we see video as sort of being more mechanically objective than other forms of evidence. Of course, many of you are probably familiar with this case. This is a screen grab from the decision of Scott versus Harris, screen grab from a video of a police chase that actually the Supreme Court posted to their website and linked to in their decision. And as you can see, this is just, of course, one single screen grab, but it's very dark. It's sort of low quality video. But the Supreme Court, in reviewing this case, came to a different conclusion than the lower courts had come to in terms of what the video shows. And they said, quote, the video tells quite a different story. The Court of Appeals should not have relied on such visible fiction. It should have viewed the facts in the light depicted by the videotape. Again, evidence of this sort of this sort of idea that video is objective on its own, and sort of it says essentially what it says is clear, and it says one thing, despite the fact that a lower panel of judges came to a different conclusion in that case, right? So that's just, again, to set the stage for some of these other things I'd like to talk about here, focused on body-worn camera video. I'm going to show a couple of images that were taken by officers that I've worked with in some of the research that I've done. These are not sort of the broadly seen images that we see all the time, but they're interesting in it for several reasons. This first one was a situation where a bicycle officer had stopped this man who we see here running on the sidewalk and started to question him. Didn't really explain, at least on the video, exactly what the purpose of the stop was, but it seemed to be something to the effect that he thought that he saw this individual potentially engage in a sort of handoff of illicit drugs or something. This man began to sort of get fairly agitated. Told the officer that he was racially profiling him, and then took off and led the officer on a foot chase. Was eventually arrested. From what the officers had told me in this case, this was done during an initial trial and evaluation of the cameras before they had adopted them or actually piloted them across the full force. And this individual pled, among other things, not guilty for evading arrest and resisting arrests and so forth. The police department sent the video over to the defense attorney, and very quickly the plea changed, and they pled out guilty to that charge, and the case was closed. And the police department saw this as a huge win for efficiency, and it was one of the major reasons why they chose to adopt cameras in the first place, right? So that the video had the capacity then to promote efficient settlement in the plea bargaining stage. Another theme, and this is only one example of this, but another theme that I saw in these interviews with officers was that video like this of sobriety tests, right? Watching people during a sobriety test after being pulled over for being supposedly driving while intoxicated. Officers felt like this, and in some other cases, right, that this was much more powerful evidence than an officer sitting in the witness stand and sort of talking about from their notes how a person slurred their speech, couldn't recite the alphabet, stumbled off the line, right? If you could watch it, the officer said it was much more powerful. And so they really liked that the ability, the affordances that this sort of video provided them when they were testifying in a case like this. The other example here gets to certainly gets to, as the others do as well, but to a bit more extreme, to the privacy concerns that Mary was also discussing earlier. I've sort of censored out or blocked out, redacted this young woman's face here, but the video itself made it to YouTube as to these others after public records requests. But this was about a 35-minute interview with a young woman who'd been detained and questioned in a prostitution sting. And this entire video, all of the audio and video for this, as well as several other videos related to that incident, were all recorded. They were posted. They were accessible under public records laws and then posted to the internet. So again, I'm not going to spend too much time here, but it's important to focus on and to remember those privacy concerns that Mary was talking about a moment ago. Cameras officers are wearing, the technology has been developing rapidly. This was an example of sort of one of the earlier Axon or Taser models that police started using in some of the agencies I was working with back in 2014. And some of the things, and also getting towards sort of their perspectives about report writing, some of the things I noticed I thought were interesting in terms of what we get on this video, that sort of evidence we might have because the video exists that we may not have as much of before, was some officers, and I observed this, would narrate to the camera. So they would, and one of the officers, when questioned about this, told me that she felt that if she turned the camera on before she got to an address where we were headed, that she could talk to the camera and put down on tape essentially what her expectations were, so that if she thought this was going to be a very hostile situation and she jumped out sort of with her gun in hand, her mindset would be captured on the video, and that would be understood better than if you just saw the video start after the gun was out and things got violent. The main point here that I want to focus on is here this issue about whether police might align their written narratives, their written reports, with what they see on the video, rather than report from their firsthand perspective as they typically have. And this was Mary discussed, right? Officers should be judged as sort of as the officer, a subjective experience of the officer, reasonable officer in that moment. But if officers are reviewing footage, there's a potential that what they actually report will become different, which makes interesting implications for how their conduct is judged. So at one Midwestern police agency that some colleagues and I did some research at, most respondents, about 70% of the patrol officers in that department agreed that they reviewed their footage at least sometimes when writing use of force reports. Lower numbers, not majorities, reported that they felt that it significantly impacted the nature of their reports and so forth, but a majority of them actually reported that they did view it as they were writing reports. So there's always the potential that it could impact what they were writing. Officers often reported that they augmented what they remembered with additional details that they missed in the heat of the moment, or to make the reports more complete or accurate. And those are words that I heard over and over again, and we heard over and over again in interviews with these officers. And one of the detectives at that agency said that, quote, even if you believe it's truthful in your mind, the video doesn't lie, right? So essentially getting at the fact that even if you thought you saw something or thought you perceived something in the moment, if then you look at the video and it seems to show something else that contradicts what you experienced, well, the consensus was among many of these officers, well, they wanted to represent then in their report what they had seen on the video, because that's what they would be judged by ultimately, is sort of what other people might see in that evidence. So that significantly has the significant potential to impact the nature of what we get, right? It's a change in what in sort of reporting that police officers engage in these sorts of incidents, if they're writing for the video rather than writing based on their perspective during the incident. A lieutenant at one of the agencies in the Pacific Northwest where I did interviews said that, quote, anything can help me write better reports and provide better evidence is helpful. So again, this is one of the officers who felt that reviewing video was actually beneficial. They liked doing it because they thought it, again, provided better evidence of what had happened. These are two different patrol officers, a sergeant and another patrol officer at this Midwestern police agency, talking about the details in their reports. And so the sergeant said, quote, "I used to paraphrase more what people said. Now I don't anymore. I just say, see video," right? Essentially, and I heard this from other officers where they would, some of them lamented the fact that they couldn't just say, see the video, that the department was actually making them still write full reports. But many of them saw that tension between sort of what the video evidence might show and what they would otherwise be writing. And they wanted to be able to just say, well, see the video for what this discussion entailed and so forth. The other officer said, quote, "that the more details that you put in a report sometimes can hurt, just because you've got to be able to testify to all of that in 5 years when it goes to court." So again, another tendency potentially to reduce the amount of detail that they included here, because they might have to testify about that on the stand. Moving back to the Pacific Northwest, another patrol officer here told me that recognized that different angles lead to completely different interpretations of the incident, which is recognizing, of course, something that Mary also talked about. And also said that, quote, "one view does not give an accurate account of what occurred, and I doubt that the general public will understand that." And this statement was made in a sort of broader discussion of concerns about how the public will react to and potentially in the police officer's mind misinterpret what they see in the video because of for various reasons. And again, so I'm concerned about accountability based on something that the officer felt was evidence that showed something different than what the officer experienced in the moment. A corporal at that agency said that, quote, "right now we're having issues getting our footage into court and then having it used against us. For example, officers discussing probable cause and the defense saying that we didn't know what we were doing. It's a double-edged sword in court." And then this interview was back in 2018. So it's a few years old. These officers and many others around the country have had a lot more experience with cameras in recent years. But I just wanted to highlight with this some of the fact that the evidence in terms of the written reports in connection with these videos in many places may be changing, particularly if police department policy allows for officers to do pre-report review and doesn't require something like an initial report and perhaps an addendum afterwards, right? Essentially to say, well, after watching the video, I also noticed these details, or I realized that I may have been mistaken about something, right? But a lot of it, so it really, what the police department's policy says and what it requires and how it's enforced has a lot of importance here as well. So I'll end there and turn the time over to Rebecca.
All right. Well, thank you so much for having me. It's a pleasure to follow these two interesting and exciting presentations, and really appreciate the chance to share some work today that I did a number of years back with Sandra Rostovska for a book that she edited. I'm going to share some thoughts with you about body cam footage, privacy invasions brought up by my co-panelists, and possible Fourth Amendment protections from video footage recording. And so the ideas that I'm going to share today are meant to be thought-provoking. They do not describe current doctrine. They are more of a thought piece and speculative about how the way we understand visual recording technologies could alter which judicial doctrines get triggered. So focusing specifically on body camera footage as evidence that might be introduced in court. Is there a place for Fourth Amendment protections to limit the initial capture of body cam video recordings? That's the idea here. And the question is, well, what legal rules should apply, or what legal rules could apply? There's very little doctrine on this. There are no courts today that have held that the Fourth Amendment stops police officers from recording body camera footage. However, this is an open space in the Supreme Court doctrine. There was a case in 1999, Wilson versus Lane, where police officers executed a search inside of a private home. That was a warranted search, they had a warrant for it, but they invited a camera crew along, a television camera crew along. And the Supreme Court found that the television camera crew exceeded the scope of authorization from the warrant, that the search itself was lawful, was constitutional, but that adding in the video recording was not. So how do we get from that understanding in 1999 to today, when it's routine for cameras to accompany officers into home searches and for that video to appear in public view? The thesis that I want to propose that we could think through maybe in the Q&A is that how we understand what body cam technology or other visual recording technologies do is going to affect the answers to their lawfulness or constitutionality. So the first question that we can ask from a Fourth Amendment perspective is a body cam video recording a search? And there's two different ways to understand what video does. One is there's the moving image component of it. This is a series of still photographs, still works this way. They get added together in a frame and it looks like a moving image when you speed them up at 24 or 30 frames a second. And the other part of the video recording, of course, is the audio. And so body camera footage is bring these two things together. Now, does it make a difference how we talk about body camera footage for answering this question, is the video recording a search? Well, it turns out way back in the day in 1980s, Judge Posner on the Seventh Circuit actually wrote an opinion analyzing whether video recordings should be analogized to still photography or to audio recordings for purposes of a Fourth Amendment analysis. And his opinion was that an image of somebody is much more privacy invasive than audio of that person. And so he thought that some protections in that case should apply. However, so balancing this in terms of Fourth Amendment reasonableness and reasonable expectations of privacy, you might think, okay, well, if we analogize body camera footage to, we focus on the image component of it, it's more likely to get Fourth Amendment protection than the audio component. However, the audio component has a different aspect of it that might ruffle Fourth Amendment feathers, which is that it's far less discriminate in what information gets captured. So with an image, you still have some framing element. Body camera footage, it's not a voluntary framing, and yet it still does have a perspective. It's not capturing everything. It's designed that way about where you put it, how you wear it. Audio recording indiscriminately captures anything that reaches the sensor. And so if we start to think of body camera footage as more indiscriminate, it's likely to interfere with the particularity requirements of the Fourth Amendment. So the possibility for why this might trigger Fourth Amendment search doctrine and how that analysis could play out. Another way, and by the way, these are drawn, these frameworks and this reasoning is drawn from early court cases that were dealing with photographs and videos in non-covert, in-person, in-home searches. So another question we could say, well, is it a seizure? Now, some of you know, I'm sure the Fourth Amendment seizure doctrine requires that something that interferes with a possessory interest might be a seizure. So say, okay, well, unlikely that an image recording is going to interfere with my possessory interest in an object, but there's at least some basis in copyright law for saying that if you have intellectual property in a sculpture, architectural details of a building, then image recordings could in fact interfere with that property interest. So maybe there's a way of thinking about video recordings as seizures of some kind. And now that might implicate a different part of the Fourth Amendment doctrine, which is you say, okay, well, this is in plain view. My officer goes into the home, they record things that are in plain view, and this is a possible home search where you could record things in plain view. But in order to seize evidence that an officer sees in plain view, the incriminating nature of the evidence has to be plainly visible. So you can't just seize everything during the home search and say, well, I saw it all, so I took it. No, you can only take the stuff that has an incriminating nature. And here again, the lack of particularity in video and audio recording could potentially ruffle feathers on the plain view doctrine. Now, the more common way for courts to reason about visual technologies in searches is instead to say, no, what's going on here is not a search, it's not a seizure, it's mere observation. And this goes back to some very early Supreme Court cases that dealt with binoculars and magnifying glasses and said, effectively, if what law enforcement officers are doing when they use some technological enhancement to observe is simply more easily getting information, visual information that they would otherwise be able to get with the unaided eye, then there's no problem here. There's no legal issue. It's simply mere observation. And so I want to throw out a proposal, which is that as technologies become more commonly used throughout society, we become familiar with them, we're more likely to categorize them as mere observation. When it's novel technologies, and some of you who know the Fourth Amendment doctrine might be thinking Kylo, thermo imaging cameras. When it's novel technologies that aren't in general use in the public sphere, we're less likely to think that this is mere observation, instead to think it's some other kind of collection. So I want to now go from way back in history to way future in time and think, well, what really are body cameras and what might they become? Is it just the video signal, an image signal, image light sensor that an algorithm turns into a video, an audio sensor that's recording? Actually, cameras already have more data collection involved than just that. They collect metadata. They collect data on time. You know, there could be a timestamp, could be location stamp. There have been proposals to enhance cameras with additional metadata for authentication purposes. For cameras you might want to bring into a human rights violation space to document things. They could have GPS information embedded into that data stream. So why stop there? In the future, perhaps body cams will have other kinds of sensors, chemical sensors, weight sensors, who knows what kind of sensors, all added, embedded inside of that same device. Now, with that understanding, do we want to call these mere observation? And with that, I will open to discussion.
Thank you so much, Rebecca, and thank you so much to the three terrific and enriching, thought-provoking presentations. We have about 15 minutes for questions, which is excellent. You can type in your question in the chat or just go ahead and ask your question.
I see Judge Kennedy is saying there's additional technologies here that you can point and get more sensor data identifying other kinds of information. So maybe Judge Kennedy, and sorry, Sandra, I don't mean to step.
No, go ahead. Go ahead.
Do you think of this as a search or a seizure or mere observation?
I picked up the idea from a Washington Post article yesterday that they're doing on the fentanyl crisis, where you can have a handheld X-ray spectrometer and actually figure out what's in a closed container. And it has a reference library of the spectra for various drugs. So it just pops back and says, yeah, you got fentanyl, or you've got whatever. And that seems to be a pretty close parallel to Kylo, where all of a sudden you can point an infrared sensor at a house and see people moving around inside. That even Antonin Scalia said was an intrusion far beyond mere optical. Looking in a window, for instance, that might be open. And I think that I think that's certainly a direction that that things are going to be going.
I wonder too if there's a way to think about images, magnification, the act of recording itself as going beyond what you would do when you just look with your unaided eye through a window. Though just the fact of recording that you can afterwards go through it is something that a human being can't do on their own without technological enhancement. So this is just, where do we get this line where thermal imaging with a spectrometer seems to me unusual and not unaided observation, but why do we think that a camera is unaided observation?
Well, obviously some cameras aren't. I mean, I'm a hobbyist. I've got a lens that can take a very clear picture of a very small building at half a mile, and you can see all the pretty much every panel in the outside of the little building. And that's at sunset.
Wow. Yeah.
The quality of optics and sensors these days is nuts.
We have another question in the chat, which is addressed to all the panelists. Best resource for police department policy, best practices for body-worn camera usage.
Well, I'm happy to say a couple of things in there. I think there's lots of places for resources, including talking to other agencies, right? If you're an agency, I think that the agencies I've worked with have gained a lot from talking with others who've done it before them. There's I shared it in the chat, but there's a national body camera toolkit that was put together by as part of the Bureau of Justice Assistance Programs that provides some policy advice and things like that. Michael White at Arizona State has done a lot of work with that group, and there's some interesting and useful stuff there. As a researcher myself, I think there's also a lot of research that's bringing up other questions, other issues, right? I think some of the issues that we've addressed today aren't those that show up in some of these, necessarily aren't addressed in some of these policy guidance as well. So I think my recommendation would also be just to try to keep a sense of, it's exploding literature, but to get a sense of sort of that potentially even contradictory sorts of findings that we're getting with some of this research, right? In terms of what the cameras do, what they don't, what sort of impact they have, because often it's situational and contextual. And what works in one place within a variety of certain contextual factors may not necessarily work somewhere else. So you have to also know sort of what sort of context you're operating within as well.
I'll just
add. The Police Executive Research Forum does a lot too.
That's right. I'll just add there's model policies issued by various groups. So you could go to the International Association of Chiefs of Police, has a model policy. PERF has a model policy, as the judge notes. ACLU has a model policy. The ACLU National does. ACLU Local may have a different policy that they prefer in terms of how to balance these hard questions. And so there are a number of model policies. And so I think one important thing is to know the community that you're in and the policy constraints that you're in to see which one fits, because they're from different worldviews, frankly, depending on the organization. And you may have to take bits and pieces from some.
Any other thoughts, questions, comments from the audience? And if you would like to speak up, you can just unmute yourself.
I mean, you can see a link to our home policy on body worn cameras with the Albuquerque Police Department from Chief Griego, who just put it up. And we have mandatory use.
And I guess if we're sort of waiting waiting for questions, I'll also say that one of the things that some of these policies don't always get is, again, some of those contextual factors, like some of the work I did in Washington dealt with the fact that at least initially when we started, and the law has changed since then, but basically all body camera video, when officers started using it in Washington State, was subject to public records requests almost without the possibility for any redaction, right? And so that, I think, these policies are never really written often sort of in the broader frame of thinking about how these other laws that sort of exist around this space might also interact with the adoption of certain technologies. And we have to take those sorts of things into consideration, not just public records laws, but others that may also impact the communities and the areas in which the cameras and the technologies are deployed.
This is Chris Schmaltz. I asked the best practices resource question. I'm general counsel at the Tucson Airport Authority here in Tucson, and we have a police department here at the airport, and I in fact accessed many of these policies and resources that you've listed. One of the key factors in developing our policy included that open meeting law or open records, public record issue. And so we adapted and changed some of the templates to explicitly require that the release of that footage is at my discretion, not the chief of police discretion. And so to deal with exactly the issues that you're talking about, and I want to make sure that our policy is keeping up with evolving data and research with regard to its use and requirements of our officers and their use, et cetera. So I appreciate the panelists and the information today very much.
Thank you so much, Chris. And we have another question. What are the best practices for custody retention of body cam footage that you know of, you're familiar with?
So I'll say that when body.
Oh, Mary, you're muted.
Sure.
Oh, we can hear you now.
So the retention varies substantially from department to department, and the reason why is because of data storage costs, and the ability of small departments to pay those costs will differ than in contrast to major city departments, whether they can store the data in-house, etc. So, you know, I've seen a range of custody retention terms, but certainly some broad principles is that at a minimum, if a case is going to either go to trial or there has been a complaint of some sort, then there needs to be retention policies that go for the life of the case and the appeal. And so there's, in terms of, you know, there's a lot of footage of everyday interactions that'll never get contested. You know, there you're going to see particular variance in terms of deletion of that data.
And now
I might just,
go ahead.
I just want to say a couple of things there. I think that, right, it does exactly as Mary said, it varies based on the agency, based on the state. There are certain state-based retention policies in general that are sort of in place. But I think it also raises the important sort of broader policy question about whether or not we want police to be able to maintain, you know, archives of this sort of data, even after it may not be related to an ongoing investigation or a particular case. And there's a variety of types of video that don't, right? So very quickly after one of the policy changes that one of the agencies I worked with had to implement very quickly during their pilot was, what do you do with video? For example, if a police officer forgets to turn the camera off when they go to the bathroom. That happened within the first couple of weeks, and they had no policy that would sort of allow them to redact some information, some videos like that had no real evidentiary value outside of you know, to ongoing cases or to officer accountability and so forth. And there were a real big impasse, right, about what to do. So again, think about these things beforehand. But one of the things that happened was that they would tag each different types of footage. They were allowed to flag them, and different flags would then correlate with a different retention schedule based on policy of the department. That's one way that I've seen departments go about this. But some states don't have any sort of broad data retention policies at all, so it's often up to the individual agencies. And so agencies in nearby communities or within a single state may have very different policies in some places. And so again, focus on that broader picture question, which I think, as a sort of privacy and surveillance scholar, I don't think that we want police to be able to mine all of this video for years to come, or to keep it just in case something arises in 5 years that might involve someone, right? But those are questions we have to ask, because if the data can be retained, it can also be analyzed into the future. So it's a good question.
I see Christina speaks.
And related to this question about retention and storage is another question in the chat asking about existing policies regarding other questions like the integrity of the footage, you know, editing forbidden, editing allowed, enhancement forbidden, enhancement allowed. How is it stored, not just beyond, so going a little bit beyond retention. Are there any policies that you can speak of in regards to these issues?
So Christina, I'm a huge fan of your book, Law on Display. So I was really excited to see you in this webinar. With respect to integrity of the footage, Provisions again vary. I guess it's the standard lawyer answer. It depends. It varies. However, there are actually there tends to be policies with respect to access, who can access, especially officers involved, whether or not they can access the footage, especially. And there are also debates about whether or not officers who are involved in an incident can access the footage before writing their police reports, for example. But there are security systems. There's secure storage systems that create a sort of an audit trail of who has accessed the footage. I'll let my colleagues Rebecca and Bryce jump into more about that technology.
Thank you. Thank you very much.
I'll just say that another policy to think about here that I think is important is sort of the policies of the tech designers, right? The tech companies that are producing the technologies as well. When I started doing this work back in 2014, one of the selling points that I heard, and I interviewed a number of folks from some of these body camera companies, including Axon, and they said that one of the selling points, and I think this was largely, it was interesting because the camera quality was fairly low. And one of the selling points that they used even in pitches to police agencies was that the camera wasn't going to work better in low light than an officer's normal vision. That has since changed. Cameras, including by that same company, have then evolved to become better at low light capture. But so those sorts of technological decisions, the way that the technology is designed, and the policy questions that go into that also inform these questions about enhancement, right? So if the camera is recording better video than what an officer could perceive, and we're supposed to judge an officer based on what they could perceive in the moment, then that raises some interesting questions, because everyone who watches the video can see potentially a lot more than what the officer could.
There is one more question in the chat, and I'll use my moderator rights to ask one question of Rebecca, because we have 2 minutes to close the session. So the question from the chat is about how common is the practice of officers getting to review their footage before writing reports. Maybe Bryce or Mary can speak to this. And to Rebecca, we have one of the things with visual evidence of all sorts has been to keep drawing analogies. As Jennifer Mnookin has told us, right, photograph became like maps and diagrams. Then film and video became photograph plus sound. But each of these technologies is actually something unique of its own. That something important gets lost in that analogy. And now digital video today is more than video of the 80s or video of the 90s with the inclusion of metadata, right? So when you talk about thinking of video potentially on the spectrum of bulk data collection devices may be a better analogy than thinking about just the sound and an image. So I guess my question to you is, do we need to, beyond just the analogies, which are useful and they have a place in the law, but do we need more serious engagement with the technology on its own right? Because other issues may be neglected that are critically important, as in the case of, police body cameras, and your provocation to think about Fourth Amendment implications, which may not be as obvious today, but potentially are, coming in the near future.
Do the other panelists wanted to talk about reviewing the footage?
I'll just say very briefly, policies are mixed, and this is a sharp, and partly they're mixed in part because some jurisdictions have strong police unions with strong views about this, and others don't have unions or may have unions that don't have as strong of a view. But so there is a sharp mix. So some places like Oakland, for example, have policies that bar their officers from reviewing videos if there's a use of force incident. The idea is it's going to taint memory. There's a best practice. The problem is you're going to taint memory, and it's also going to hurt the officer too, because sometimes the camera sees things that the officer really didn't see, and then there's like pressure to conform honest recollection to the video. And so there's pressures on all sides, as well as, of course, collusion in terms of fabricating things is another concern on the other side. So the jurisdictions do vary. Some have hard nose and some do not.
I think we're at time, so to say, Senator, thank you for emphasizing this point about cameras potentially becoming bulk data collection devices rather than what we used to think of as a classic image and sound capture device. And what Bryce and Mary are talking about cameras that can see more at night than an officer could see is just another example of that. What is the technology becoming? Do we have the right categories when we think about it analogically in the law? And thank you so much.
Thank you all so much. So on that note, I would just like to say huge thank you to Lionel Delamora and Barbara Mitchell on the ABA Science and Technology Law Section staff who have been critical behind the scene, enabling this series to happen. To Laura Poseski, who is the incoming chair of the Science and Technology Law Section, and Judge Kennedy, the co-chair of the Scientific Evidence Committee. It has been wonderful to collaborate with them all, and they've been all critical to making this series possible. To our panelists for doing an amazing job of kind of really with these thought-provoking presentations that I hope will inspire people to look even more into the specifics of the issues that were raised today. All of the webinar series are uploaded online. The recordings are online in case you want to consult them. And on that note, I thank you all very much, and I wish you all a very happy holiday season. Goodbye.